Welcome, everyone. It's 2 past the hour, so I think we're good to start. Welcome to Crim-Imm Basics, Understanding the Interplay of Immigration Cases and Criminal Law. And this is presented by ILSAA, the Immigration Legal Services for Afghan Arrivals. And we have 2 fabulous panelists with us today. And we could before we get into that, a few housekeeping notes. This webinar is being recorded and it will be available for future viewing on the ILSAA Peer Networking Hub, which we'll have more information about at the end of the webinar today. And we want this experience to be interactive, and participants are encouraged to share thoughts and or comments using the chat. And we also have a Q&A box that you can use throughout the webinar. We're going to save questions for the end of the webinar, but please, as they come up, feel free to add them in real time, and then we'll get to them at the end, or get to as many as we can. And should you experience any technical issues during the webinar today, please send a private message to Hannah Deek, and we will do our best to assist you. And then at the end of the webinar, an evaluation link will be shared, and we will also be sending the presentation slides. And as far as our agenda for today, first, I'm going to do some introductions for our panelists, and then we will overview some Crim-Imm basics, and then delve into understanding the issues, and then defining what a conviction is in immigration law, and then talk about ethical requirements / next steps for once your client might have a conviction or some other Crim-Imm issue. And then we're going to talk about avoiding admissions of guilt, and then jump into Q&A before we go into resources and closing. Right, and our first fabulous panelist today is Wendy Wayne. Wendy is an expert in immigration enforcement within the criminal justice system and in the interplay of immigration and criminal law. She is the founder and director of the Immigration Impact Unit at the Committee for Public Counsel Services, or CPCS, which is the Massachusetts Public Defender Agency. She is the former chair of the American Bar Association Commission on Immigration, and she currently sits on its advisory committee. And then we also have the wonderful Homero Lopez Jr. Homero is the legal director at Immigration Services and Legal Advocacy, or ILSAA, where he focuses primarily on representing detained immigrants throughout Louisiana. He has 13 years of experience representing immigrants before immigration courts, U.S. Citizenship and Immigration Services, or USCIS, the Board of Immigration Appeals, or the BIA, and U.S. Courts of Appeal. And I will turn it over to Wendy. Thank you so much.
Thanks so much for having me. I'm going to cover in the next 20 minutes what could easily be a lecture or presentation of a couple hours or days or weeks, depending on how deeply you want to delve into this area of law. I'm going to give you a really fast, really brief overview of this area of law. I've put more information in the slides. The slides are sort of designed, we're going to go through them, but they're also designed for you to be able to use as a little bit of an outline when you're thinking about cases you have when you're representing people who have any kind of criminal history. So I hope that they're helpful. You know, the slides in this are helpful down the road. But this is really just the tip of the iceberg. So I'm going to start by, in order to understand the impact that criminal charges or convictions have on an individual client, you have to know what the person's current immigration status is, their history of immigration, if they're applying for some type of immigration status, if they have pending criminal charges, what are those, and what would the impact be if they were convicted on them, and any prior criminal history. So, for example, you know, in my role, in my day job, people will often say, I have a client charged with assault and battery. What are the immigration? He's not a citizen. What are the immigration consequences? I can't answer that question without knowing a lot more information, because it's this Venn diagram. It's sort of the interplay or the intersection of those 3 things that determine what the immigration consequences will be of that particular charge. Next slide, please. Okay, so the possible immigration consequences of criminal charges. It can bar status, lawful status. It can bar relief, denial of asylum, temporary protected status. Criminal charges can bar any kind of lawful status for your Afghan clients. It can fall under a ground of inadmissibility or a ground of deportability. And I'm going to go over those in some more detail in a few minutes. But there are categories of grounds of inadmissibility that are relevant when somebody is either physically entering the United States, they need to be admissible, or if they're physically in the United States, but they're applying for lawful status, such as a green card, they need to also be admissible. And so criminal convictions that make them inadmissible will be a problem. For deportability, once somebody has been lawfully entered or has lawfully entered the United States, certain categories of criminal offenses will make them deportable. So you may come across clients who are here lawfully, they have legal status, they have a criminal conviction that makes them deportable, or they're here on a visa or some type of temporary status, and they want to apply to adjust status to become a green card holder, and this conviction makes them deportable and it makes them inadmissible, meaning it bars their adjustment application. Or you may have people who aren't deportable, but they need to leave the U.S. to go visit family in their home country, or otherwise leave the U.S. And although they're not deportable now, they may be barred from re-entering the United States if they leave. And so the grounds of inadmissibility and deportability, there's some overlap, there's some significant differences, and they impact clients differently. Next slide, please. So a conviction is normally required, but not always. And Omero is going to talk about that a little bit more later. Some categories of deportable or inadmissible offenses, just by their definition in the INA, do not require a conviction. When clients are in criminal court, you're trying to avoid a conviction for the most part, because the conviction will often be what's used against them in the immigration proceedings, even if less than a conviction is required. But in most situations, a conviction is required. And a conviction has a statutory definition in the INA, which is basically two prongs. There needs to be a finding of guilt or admission of sufficient facts that a judge could find you guilty. There needs to be that first. That's the first prong. And then there needs to be some punishment, penalty, or restraint on liberty. So there are some dispositions that, so for example, an Alford plea or a plea of nolo contendere, which some of you may have heard of, that is not a guilty finding as though you go to trial and you're found guilty after trial, but that's a type of plea where the judge may say, I'm not going to find you guilty, but I find that the government has enough evidence that if you went to trial, you would be found guilty. So you don't have to, the defendant doesn't have to admit guilt, but the judge makes a finding that there's enough evidence to be found guilty. That's an admission of sufficient facts. So that's a finding of guilt or admission. That's sort of the first prong. And then if there's any type of fees, fines, conditions, anything that the person is subject to as a result of that finding of guilt or admission to sufficient facts, that meets the second prong, and that makes it a conviction. So, for example, in Massachusetts, there are some dispositions where you have the first prong, there's a finding of guilt, but there's no punishment, penalty, or restraint on liberty. So it's not a conviction for immigration purposes. There are other dispositions where there is no finding of guilt or admission to sufficient facts. The person is placed on a type of pretrial probation or pretrial conditions. And there's the second prong, there's a punishment or penalty or some sort of conditions placed on the person. But if they violate the terms of that probation or that pretrial status, they haven't waived their right to go to trial. They haven't already been found guilty. And so they are then sort of put back in the normal course with the option of going to trial or pleading guilty down the road. So every state has different types of dispositions under state law. Most states have something called deferred adjudications, and the overwhelming majority of what states call deferred adjudications are convictions for immigration purposes, because there has been an admission of sufficient facts. And even if under state law, the case gets dismissed at the end of the period of probation and the person is not convicted for state law purposes, that constitutes a conviction for immigration purposes. So anytime you have a client who's got criminal charges from a state, it is really important to talk to the state defense attorney to find out what is that sort of vehicle that they're using in the disposition, and is that a conviction for immigration purposes or not? Next slide. Juvenile dispositions are not considered convictions for immigration purposes. Many states have something called a youthful offender adjudication, which is sort of for very serious crimes for older juveniles. And the way there's some case law that finds that some states' youthful offender adjudications constitute convictions, and there's other states where immigration case law has said they're not. It's on, it depends on the state where the person has a YO adjudication. However, it's important to note that it doesn't mean that juveniles never run into trouble when they're charged with juvenile offenses, because some grounds of inadmissibility and deportability don't require a conviction. So juvenile dispositions can still have immigration consequences. Next slide, please. Okay, so this little chart is a good one to keep handy, because it lists on the left side the grounds of inadmissibility, the criminal grounds of inadmissibility. These are the categories of offense that will make a non-citizen inadmissible. And then on the right side of the slide are the categories of offenses that constitute grounds of deportability. You'll see that both of them have crimes involving moral turpitude, although the requirements are a little different for each one. Both of them have controlled substance offenses. We're going to go through each one of these in very little detail, but in the next slides, but you'll see that there are some that are the same and some that are different. For example, aggravated felonies fall under grounds of deportability, not inadmissibility. So do firearm offenses, whereas prostitution falls under grounds of inadmissibility, but not deportability. Next slide, please. Okay, so crimes involving moral turpitude. This is there is a tremendous amount of case law and really poor, loose, vague definitions as to what constitutes a crime involving moral turpitude. There was, after about 150 years of case law, in 2008, Attorney General Mukasey threw out all the old definition, created a new definition, but a lot of the case law still refers to cases that have been decided under the old definition. So that being said, the best way to figure out if an offense is a crime involving moral turpitude is really to research that particular, if it's a state criminal offense, that particular state law, has it been interpreted by the Board of Immigration Appeals or a federal court in the immigration context. If it hasn't been, is there a criminal statute from another state that has similar elements, similar components, and you can make an educated guess that, yes, this is really similar. This assault crime is really similar to this assault crime in another state, so this is probably going to be considered a crime involving moral turpitude. That doesn't mean that there are not arguments against a finding of something being a CIMT. And I just want to say, going forward, everything that I'm saying here is what is traditionally found to fall under these categories of offenses. But never, ever, ever concede anything unless you are positive that there is no viable argument as to why a criminal conviction or criminal offense doesn't fall into one of these categories. Especially in the last 10 years or so, when there's been there have been some very significant cases from the Supreme Court and circuit courts around the country about something called the categorical approach, which is a whole nother presentation for another day. There are arguments about things that have traditionally been considered a firearm offense, for example. And now, because of case law about the categorical approach, a particular Massachusetts criminal, firearm charge is no longer considered a deportable offense. And so as immigration lawyers, you don't want to assume any of this. You want to challenge that something's an aggravated felony or that the government's alleging that something's a crime involving moral turpitude if you can. That being said, CIMTs tend to be, and the definition used to be sort of regulatory offenses that don't have any real intent, they're just general intent crimes, tend not to be CIMTs, whereas offenses that have something recklessness or specific intent and some type of reprehensible immoral conduct will tend to be CIMTs. So theft and fraud offenses are almost always considered CIMTs. As far as crimes of violence or violent offenses, simple assault offenses tend not to be, but anything assault plus an elderly victim or a child or assault with a dangerous weapon or indecent assault battery, those tend to be considered CIMTs. I have a couple other miscellaneous ones listed here. Malicious destruction of property. It's a Massachusetts offense, and it's kind of like vandalism. And in order to be convicted of that, you have to prove a specific malicious intent. And because of that, that's been held to be a CIMT. So the middle column and the column on the right have the what makes someone inadmissible for a CIMT and what makes someone deportable for a CIMT. So except for this, they're basically one CIMT conviction will make somebody inadmissible. However, there's something called the petty offense exception for very minor offenses, and it's listed here. Or if it was committed when the person was 18 years old and it was at least 5 years before they're seeking admission. For deportability, within 5 years of lawful admission, so depending on if you have a client who obtained asylum and then is applying to adjust status, when is their date of admission? Sometimes you've got to do some serious research on that. Their date of admission for that would be the date, if they entered without lawful status, it would be the date they obtained asylum. But if one CIMT committed within 5 years of their lawful admission makes them deportable, if they were lawfully admitted more than 5 years ago, they need 2 separate CIMT convictions to become deportable. Next slide, please. Controlled substance offenses. So anything except you will see under the inadmissible, and actually under the deportable ground, there's an exception for 30 grams or less of marijuana. As for inadmissibility, there is a waiver that is available for 30 grams or less of marijuana. Any other drug conviction for simple possession, distribution, trafficking, conspiracy, makes someone deportable, but more importantly, it makes them permanently inadmissible because there is no waiver available to get a green card, to become an LPR, to adjust status, for somebody who has a conviction, even just for simple possession of cocaine or simple possession of anything other than 30 grams or less of marijuana. And then we'll talk later about controlled substances also fall under the aggravated felony category. Next slide, please. This was listed if you went back to that slide that had the sort of lists of inadmissible and deportable offenses. Multiple offenses falls under inadmissibility. I have rarely seen this charge because immigration officials usually have lots of other charges that they can go on. They don't meet this one, but 2 or more convictions where there has been an aggregate sentence of more than 5 years makes you inadmissible. Chances are your client's already inadmissible under a bunch of other grounds as well. But next slide. Prostitution is a ground of inadmissibility, not deportability. But I have a note here that some prostitution-related offenses may also be CIMTs. Although immigration officials will allege that someone is inadmissible for one conviction for prostitution, the language in the statute says engaging in prostitution, and there are strong arguments that it really requires some sort of multiple offenses or some pattern of coming to the United States in order to engage in prostitution, not just one conviction for prostitution, but it is a ground of inadmissibility. Next slide. Firearm offenses, not inadmissible, but it does make you deportable. And I have some examples listed here. It covers most firearm offenses. However, as I said, due to the categorical approach, case law of recent years, there may be arguments, for example, that in Massachusetts, the firearm statute since 2018 includes stun guns. Stun guns are not considered a firearm under the federal definition. So does that mean that the Massachusetts statute is overbroad? And if someone's convicted of a firearm offense in Massachusetts, is there an argument that they're not deportable? Next slide. So crimes of domestic violence, stalking, and child abuse. This is a really broad category, and it includes domestic crimes of violence, which are against somebody who's protected under the domestic violence laws of that state. Stalking, which does not have to be domestic. It can be stalking a stranger. And child abuse, which does not have to be the client's child. It can be any child. And the child abuse has been defined very broadly to include any kind of crime that involves neglect, abandonment, or abuse of a child who is anyone under 18. So it's a really broad category of deportable offenses. Next slide, please. And it also includes that category under the INA, includes violation of a protective order, only a deportable offense, but it does not require a conviction. It only requires proof that there's been a violation. So it could be, for example, from a probate court. Next slide, please. Aggravated felonies are a huge category of deportable offenses and also impact denial of relief, forms of relief like asylum. And the statutory definition, or I should say the categories that fall under aggravated felonies are listed under 101A43. There are about 27 different categories, and each one of them is broad, and there's been litigation about whether various offenses fall within it or not. So again, this is an area where you really should challenge, is this really an aggravated felony? Next slide, please. Some of these 27-something categories require just a conviction. So it's a ground of deportability, has to have a conviction. Some of them, all you need is a conviction. Others, you need a conviction plus a sentence of imprisonment of 1 year or more. Next slide, please. So what constitutes a sentence of incarceration or term of imprisonment of 1 year or more? That has a definition in 101A48B, and it includes suspended sentences. So if somebody is found guilty and they're placed just on probation for 2 years, that's not a sentence of incarceration for this aggravated felony definition purposes. It has to be a sentence of incarceration that's either imposed now or it's suspended and the person's on probation, but it's hanging over their head, basically. Next slide, please. So I have listed here some common conviction-based aggravated felonies. Murder, rape, sexual abuse of a minor, drug trafficking, meaning anything more than just simple possession. All you need is a conviction. The sentence is irrelevant. Common sentence, and this is not an exhaustive list. This is just the most common ones. Crimes of violence, theft offenses, burglary, obstruction of justice. You need a conviction and a sentence of 1 year or more, either imposed or hanging over your head. Next slide, please. In addition to the grounds of inadmissibility, deportability, different pathways to lawful status or temporary status, like TPS, have their own criminal bars. So asylum, you are barred from asylum if you have an aggravated felony conviction. or a particularly serious crime. Basically, an aggravated felony conviction is considered a per se particularly serious crime and bars you from asylum. Temporary protected status, in addition to the grounds of inadmissibility that I talked about really, really quickly that are listed here, in addition to that, if your client has one felony conviction, meaning the maximum possible sentence under the statute that they could possibly get is more than 1 year, or two misdemeanors, they're ineligible for TPS. Even if they would otherwise be admissible, they're ineligible for TPS, or a particularly serious crime, which has its own definitions. And I'm going to stop there and turn it over to Amaro. Next slide, please.
Thank you, Wendy. It's a lot of information for such a short period of time. I'm going to cover some, ethical requirements, next step after you discover issues and criminal issues that come up in your case for your clients in the filing process, and what that looks like in different contexts depending on what you're dealing with. And so a big part of this is going to be, the typical lawyer answer. It depends. What's at issue is really what matters here. Kind of like Wendy covered earlier, it matters what your client's status is. What matters, what kind of charge is it? Is it an inadmissibility issue? Is it a deportability issue? What is it that's going on? Is it something that requires a showing of a conviction? Or is it something that requires or could be proven simply by admission to certain facts or to certain information? Do any of the exceptions apply? Right? Wendy went over the juvenile exceptions, the petty offense exception. There's the same scheme and conduct exception. So if there's an exception that applies, find that exception and see if you can incorporate it and get your client out of that situation. And this part, who has the burden also goes to inadmissibility and to deportability. And this goes to your ethical requirements. If it's an issue of seeking relief, if you are affirmatively filing for asylum or affirmatively filing for TPS, the burden's on you. You're seeking relief. You're trying to get this benefit. And if that's the case, then you're the one that has to prove that the person is admissible, that the person qualifies, that they don't have the criminal issue. And if the criminal issue pops up, then there's also the duty of you having to figure out, how do I do the least harm? Like, how do I not put my client in harm's way here? Because if I file affirmatively for something for them, and there's this issue that can disqualify them or that can lead them to get denied and then placed in removal proceedings to get deported, is that really what my client wants, or is that really the best interest of my client in that situation? And so those are the types of thoughts and the areas that you need to be thinking about and taking into consideration as you're reviewing a client's case. If it's in deportation proceedings and the burden's on the government, or the burden's on the government because they're trying to take your client's asylum away, they're trying to take away their green card, whatever the situation happens to be, then the burden's on the government, and they're the ones that have to prove the conviction. They're the ones that have to prove that this actually meets the charge of deportability, and that they're the ones that can't actually get this. And so then your duty then becomes to very much fight against that, to push back, deny the allegations against your client, force the government and hold the government to their burden. You're not arguing, you're not alleging anything. You're simply stating that the government needs to prove and carry their burden and prove their case against your client to be able to take away their status and kick them out of the client. A big part of this comes down to explaining to your client what is going on, what is the situation that they find themselves in, and what does that mean from a point of who has the burden, what needs to be proven, what proves it, what doesn't prove it. And then, the model rules of ethical conduct, you're bound by your client's goal. What is it that they really want? What's their end goal? And what is the best thing that you can do to get there? Can you even get them there, right? Because there might be a situation where, given the law, given the structure, given where things are, you remove yourself and you say, you know what, I'm withdrawing, or I'm not taking this forward. I don't think this is a great case to file for X, Y, and Z reason. And you remove yourself from the situation, depending on the situation. Next slide, please. And so what are those options that you run into? If you I mean, if you have a chance, right? If your client's already an asylee, a refugee, somebody with a green card, someone with TPS, and they happen to contact you, hopefully, fingers crossed, before anything happens on the conviction side, right? If you get somebody like Wendy who's like, hey, Wendy gets to be your attorney and represent them in their criminal case, awesome. But if they happen to contact you while the criminal case is working, work with the criminal defense, collaborate with them, discuss with them what the possible consequences are for your client. If they plead guilty to an aggravated felony, that's going to disqualify them from everything, right? Or basically from everything. That's going to take away a lot of forms of relief. That's going to subject them to removal. So work with them to try to, if your client is planning on pleading or your client is likely to get convicted, working with the defense counsel to figure out a way to get a plea that gets you the best available result for your client to where they're not subjected to removal or they don't become disqualified from the relief they would be seeking. So where are you in the case? And hopefully you're able to catch that at the front end. If you don't catch that at the front end, then trying to find post-conviction relief, right? And that depends on every case. I mean, every state has their own post-conviction statutes. Most, I think, tend to be about 2 years. So you have that very limited time frame within which you need to request post-conviction relief. And that post-conviction relief, given the way the case law has been happening, and there was under Trump, there was a vacature of established case law. And now the new case law is not only can post-conviction relief is one of the few ways in which you can get rid of that criminal issue. As Wendy spoke about, right? Even expunging a case doesn't get rid of it as a conviction for immigration purposes. So if you want to get rid of it, one of the very few ways of doing it is reopening the case, vacating it, and getting a different result. However, for immigration purposes, the BIA came down with a case, Thomas, that says that it can't be for technical grounds. It has to be for substantive merit grounds that the post-conviction went into place. So the overturning, the changing of that has to be for issues of merit, not simply technical issues that an attorney was able to come up with. There's no clear decision on whether that means that a criminal defense attorney ineffective assistance of counsel, we would argue, is meritorious. It's something that is based off of the merits of the case, and they had a duty to the defense counsel had a duty to advise and properly assist the client. We'll see where that ends up going and whether that gets considered something that's merit or something that's considered a technical reason. And so based off of that, that's a great avenue where you could go. If you've already filed the application and then something comes up at the back end and you realize, oh, we should have fixed this, you can always amend the application. You can, before there's been a final hearing or before there's been a final interview or whatever the situation happens to be, you can always amend it to disclose it, assuming you need to disclose it. Again, who has the burden? Where are you in the process? What's your client status? Those things will all come into consideration of whether you're going to have to disclose the information regarding your client's conviction in that manner. And then the other one, withdrawing. If it comes to a point where you just can't represent your client, right? You realize what my client wants to do, what I can provide them. It's impossible that we reconcile this, and you withdraw, or you withdraw the application maybe. So either you withdraw yourself or you withdraw the application, again, being bound by what is your client's final goal? What is their plan? What is it that they want to achieve? And so you could withdraw the application itself, or you could, end up withdrawing as the attorney, assuming they let you withdraw. And then is there any other form of relief that we can go after that this type of conviction doesn't disqualify my client from? So there's times where something makes somebody removable and it loses their green card, but then there's a process through which they can then apply to readjust, to get their green card back. And they can file waivers. And so identifying those other options for your client where you'll be fighting things on a procedural ground, but then also fighting things on a relief ground. And so making sometimes not necessarily contradictory, but arguments that might lose, knowing that on the back end, you're still going to have another argument to make regarding it. And explaining this process to your client is very much, I like to refer to immigration law very much as the logic games from the ILSAA, where like A is B because C is D and H happens to be over there for some reason. And so there's these things that are going to constantly interact with each other that might not work out at one point of it, but you're planning and you're laying the groundwork for something to come down the road later. Next slide, please. And so, again, as Wendy spoke earlier, not all convictions or not all criminal issues or all criminal grounds of deportability or inadmissibility require an actual conviction. And so there's situations where somebody can admit sufficient evidence or sufficient facts that would lead a judge to find the person guilty. And if somebody does that through an affidavit or through testimony or through a sworn statement, you end up getting your client disqualified from something because of this weird definition of conviction within immigration law that isn't necessarily what we think of conviction within a criminal context and within the more common understood definition of conviction in the legal sense. And so avoiding that is very important when you're submitting affidavits, especially because a lot of asylum applications, a lot of TPS applications will be very much, asylum really will be based on these affidavits. They'll have to show the evidence. They'll have to be able to prove the stuff that's happened. And sometimes there's issues of you're arguing that it's persecution, and people can flip it on you to say that you were the persecutor yourself, and that can disqualify you based off of the actions that you took, right? We had a client recently, he's from Venezuela. He worked within the Venezuelan National Police, and the government started making the argument that he himself was the persecutor, not that he was being persecuted. And so being very clear in your language, understanding how you're going to be able to establish the requirements to qualify for relief, then you would prepare your affidavits, you would prepare your testimony in a way that you don't disclose the information. You're not hiding anything. You're just not stating it in the way that would make your client then admit to something that's not necessarily a crime, but that can be taken as such. There is no rules of discovery in immigration court or in immigration in general, right? It's not the same system. It's this semi-quasi system where it's civil in nature, but has a very, very severe criminal, basically, consequences. And so there's no real rules of discovery. And so again, depending on who has the burden, who's meeting the requirements, holding the party to that burden in order to get documentation. A lot of the times, especially in immigration court, you'll deny allegations just to get a copy of any records that the government has against your client. That way you can understand what's going on and be able to receive the information, because there's no way to force, right? There's no Brady rule in immigration court where you can force the other party to give you copies of the documents. You kind of have to take these procedural steps where you deny allegations, you make an argument so that the government has to carry their burden by submitting the evidence they do have to your client. And then you can review that, and through that you can figure things out, right? Very much this whole trust but verify with your client. You're going to trust what they tell you, but at the same time you want to see what the government has on them. And so there are times though when you do have to turn things over, right? There's no discovery rules, but there is the need to hand over certain things, especially when the burden is on you. When you're applying for relief, you have to prove that, and everything is generally written in the negative, right? The person does not have a crime involving moral turpitude. The person is deserving of a favorable exercise of discretion. And so you need these issues there to be presented in order to prove that you qualify. So you do have this requirement of you handing over certain information. To corroborate your story, you need to hand over certain information. And so being careful about, if you have to prove that the person was being persecuted and they were being constant, and part of the way that they were being persecuted is that they were constantly being brought up on trumped up charges, a great way of corroborating that would be to show the charges against them. But if those charges against them might disqualify them because it might be a CIMT or it might be some other type of crime that disqualifies them, you're going to have to be very careful in which of those documents you hand over or under what circumstances and how you then frame everything around that to make sure that you're not admitting guilt in any of those individualized documents or the way the declaration is defined. And so then I have at the bottom, affidavits. Remember the definition of conviction. It can go beyond, what we generally understand as a criminal conviction. You can limit your testimony to the issue at hand. Don't. Oftentimes clients want to just speak as much as possible. That's obviously not always going to be a great thing. And it's same thing when you're working with third parties who are submitting declarations, who are not your client, but who are there to help your client. We're trying to corroborate the story, working with them because they don't necessarily have an attorney. They aren't necessarily attorneys. And so you have to work with them, work through, and oftentimes they're from another country writing, and they might understand the laws in a different country, but those aren't always the same as in the United States. Next. And so finally, fighting against document admission. Again, federal rules do not apply, unfortunately, in immigration court. And the test for admitting evidence is the evidence probative and is it fundamentally fair, right? Is it probative, is it relevant, and is it fundamentally fair to its admission? The rules of evidence in immigration generally lead towards admission of evidence. So it's oftentimes very difficult to fight against document admission. Due process, however, does apply, and that's very clear. Due process does apply in immigration court. And so things like police reports, you want to keep them out. Right? They are not evidence. They're not a record of conviction. They are prepared and they are intended for prosecution purposes. They're not intended to be facts. And so if they're being submitted in order to prove a fact, then what you want is get me the officer here so that I can cross-examine, so that we can question, so that we can find out what happened. Same thing goes with records at the Border Patrol interviews, asylum credible fear interviews, any of these interactions that your client has had with another officer of the government, those documents, they're generally going to come in, but the fighting against them goes to weight, right? How much weight should the government, whether it be the court or it be an asylum officer, how much weight should they give to these additional documents that exist? Because if they're not sworn statements, if they're not under oath, if they're not, if they were done, as a police report, something that's intended with prosecution in mind, then you shouldn't be giving them a lot of weight to, deny my client relief. And then there's other things like previous applications or previous declarations from your clients. They're going to be difficult to keep out. Again, generally things are going to be difficult to keep out of proceedings, but there's ways to fight them for weight. How much weight do you give to them? How much value does the judge or the officer give them? And things are, was your client represented? Did they even sign it? Sometimes they'll give me a copy of a document. It's like, sure, that looks to be filled out, but it's not signed. So I don't know who filled it out. And I don't know if my client gave that information. It's not it's not signed. What was the context? Were they detained? Did they have an interpreter? Had they just recently crossed the border after, 20 hours of traveling and not sleeping and being held in between the two walls in San Diego? Using all of that information to poke holes into the documents and the declarations as they exist are avenues in which you can fight against them. And then I think that's the end of my section.
Thank you, Homero and Wendy, for fabulous information and a lot of information. And right now we're going to move to the Q&A portion. There are some questions in the chat, but I do encourage folks to use the Q&A little pod if possible, so that way we can kind of keep them a little bit more organized for our panelists. But I will go ahead and read out some of the questions in the chat.
Emily, I did answer some of them in the chat.
Yes, thank you so much, Wendy. Thank you. And one of the questions is that I don't believe Wendy was able to get to is, when getting an RFE, a request for evidence, for a criminal case that is either pending or already adjudicated for USCIS, what type of information would be helpful to provide in a client affidavit?
Mero, I'm going to let you take that one.
So RFE context, motion to reopen, right? Or which one are we? What was the question? I was trying to look. I was reading. Oh, here we go. When getting an RFE for a criminal case that is pending or adjudicated in USCIS case, what type of info would be helpful to provide in a client affidavit? Honestly, if there's a pending criminal case, I would say you hold off on it and you let them know that it's pending, and to hold it in abeyance until the criminal case gets adjudicated, because you don't want to tell them what happened, right? The client is going to test anything they submit to you. Immigration can be used as part of their criminal case or against them in their criminal case. And so you don't necessarily, from a Fifth Amendment perspective, you don't want them to be giving over information in the immigration case that can then be pulled and used against them in their criminal case. So if it's a pending charge, I would say, hold on it, wait until it gets adjudicated. If it's been adjudicated, it's going to depend, right? If the client was found not guilty or the case was dismissed, then you submit the dismissal or the judgment just saying not guilty. If they were found guilty or they pled down to a lower crime or something, you submit that you're going to have to, for an RFE with USCIS, you're going to have to submit the disposition regardless. And so submitting the disposition, you wouldn't necessarily need an affidavit unless there's an issue that you're addressing. Even if you were doing the categorical approach, you wouldn't necessarily need an affidavit. You really just, you're going to have to submit the disposition is what it's going to come down to.
Thank you so much. And similarly, when the original arrest report has higher offenses that are eventually pled down and all that sort of stuff, how do you kind of deal with the differences between what the arrest report says and then if the disposition is significantly different?
In those, again, that one you would need an affidavit to address, right? Because a lot of forms of relief also require a favorable exercise of discretion. And while the police report does not go in to prove a conviction, it does go to the discretionary grounds. And so while addressing discretion, you're going to have to explain. I've seen this happen on a regular basis where judges will say, well, things can get dismissed for whatever reason, and maybe the witness didn't show up or whatever. And so if it's something along those lines, have witnesses write affidavits if you can. So if you have, for example, a client who has a domestic violence charge and then that gets dropped, whoever the victim was, if they're willing to and whatnot, have them write an affidavit saying, this was just a disagreement, or it wasn't an actual, I was never, there was no hitting, etc. Whatever the situation happens to be. The neighbor called us while we were arguing, called the police while we were arguing, and they arrested my husband. They said it was, domestic violence or whatever the situation happens to be. Just anything that you can find to use to demonstrate that the original charges were just they should have never been brought, right? The police went a little bit ham on it. But again, as I stated a little bit right before we finished, with objecting to admission of evidence, fighting against police report in general, you're always going to try to keep the police reports out, and they're not facts. They are prepared with the intention to prosecute. They are one-sided. They are not under oath. They are not sworn statements. Making all of those arguments, subpoenaing the officer to come and testify, or to asking the government to provide something, depending on the context, if you're doing it affirmatively or defensively. Those types of tips would be my tips, would be, just try to find a way to explain. And if there is a victim of the crime that, or the, whatever the higher crime would have been, try to get that victim to submit an affidavit if possible, basically stating, no, there was no issue here. I'm willing to say this under oath.
Thank you. And then just a follow up to the RFV discussion, RFV/motion to reopen, even if it's specifically asked for, you would look to avoid providing the police reports, correct?
Yeah. I mean, you would generally look to avoid the police report. If you give them an adjudication, they really don't have a reason to look into the police report. Again, the police report goes to discretion. If they specifically ask for the police report, I've never seen where they specifically ask for it. They use that as an example of things that you can submit, but not necessarily say we need the police report. They would say they need the adjudication of the criminal offense, right? That's what they really focus on. Is if you give them an adjudication, the police report doesn't really matter, because the adjudication is the actual thing, and for conviction purposes, what you're looking at is, or for, grounds of inadmissibility, what you're looking at is, did this person commit this crime, right? Did this person get convicted? Are they eligible? The police report does go to discretion, and so they could still, say, deny you just on the fact that you didn't submit it. Generally, though, try to keep it out if you can, to any extent.
Thank you. And I don't see any new questions, so I'm just going to go back to one of the questions that Wendy answered in the chat, because I think it's a great question for everyone to hear in case they're watching a recording. If a client comes to you after the criminal case was resolved, what are the documents that you should obtain to understand the criminal charges, the disposition record?
So you should try to, for your own purposes, you should try to get the whole court file. You're going to need to submit likely the disposition, the docket sheet, a certified copy of the docket sheet. You may or may not have to submit police reports, as Amira's been talking about. There might, the most important thing is the docket sheet. There might be police reports in there. There might be, some type of document about sort of plea discussions. There very rarely would be, a transcript of a plea colloquy, but that's pretty unlikely. The most important thing is the docket sheet.
Yeah, I would, I completely agree. Whatever you can get, if you can, and you have time, get your client to do an FBI background check just to get you a copy of anything, their rap sheet, whatever exists. But for a specific crime, I agree with Wendy, just get whatever the court file has.
Well, there's a really interesting question that somebody just asked, that there's an arrest on record, but the court doesn't have anything. So it sounds, sorry, I'll read the question. There's situations where there's an arrest on record, but no charges were pursued. The court doesn't have a record of the charges, but USCIS wants us to provide evidence that no charges were filed. What documentation would you recommend? How do you prove a negative?
That's exactly what...
In a situation where you have to prove that no charges were actually filed. My guess is that if somebody, you're going to have to do some investigation. I would say start with the police station, probably. But for example, if I heard about this happening in Massachusetts, what that would mean to me is that the client was arrested and the police asked for a clerk's hearing, and the clerk did not find probable cause that a crime had been committed, and so they did not issue a complaint, and therefore the person was never arraigned. So actually, I would maybe start with the clerk's office and say, it looks like this client was arrested. You need some specific information, but they, like in our clerk's offices in Massachusetts, they have sort of separate files for the clerk's hearings. And that's not something that you routinely ever see. But for a case that, this might have been some very well done defense work, who knows, that they convinced the clerk not to issue a complaint. But so you might be able to find something that says, no probable cause, therefore no complaint issued.
Yeah, I think that'd be great. Getting something from the DA saying that charges weren't pursued, or even, basically like the example that Wendy just gave, doing it more as a legal brief. Like in Massachusetts, this is the law, this is the way the procedure works, citing to the procedure that there would be a clerk's, and if they didn't issue anything, that's because no probable cause was found. I can't prove a negative, right? Like it's impossible for me to do. And so if no paperwork exists at the court and no paperwork exists at the DA, then no, there's no charges. And this is the way the process works sometimes.
Thank you. And does court probation qualify under the punishment, penalty, or restraint of liberty prong of the conviction analysis?
Sorry, is that a new question? I answered one that was sort of similar to that. Sorry, I don't see that question. Can you ask that question again?
Yes, sorry. Does court probation qualify under the punishment, penalty, or restraint of liberty prong of the conviction analysis?
Yes. Anything that the person is subject to because they were found guilty or admitted sufficient facts on this offense. So probation, a stay away order, fees, fines, anything like that constitutes a restraint on liberty. Absolutely, probation is a restraint on liberty. So again, if there's been either a finding of guilt or an admission to sufficient facts and probation, that constitutes a conviction. If there's been some pretrial probation where they haven't waived their trial rights yet, that would not make it a conviction.
Thank you. And what are the consequences of misrepresentation when applying for a green card or naturalization? For example, not disclosing disorderly conduct.
I mean, the consequences of misrepresentation in general, it's going to mean that the case was, or the relief, the status should not have originally been granted. And so that can go all the way back, right? So someone who's a citizen can later even lose their status based off of the original misrepresentation. The misrepresentation has to be material, though. And so if it was a mistake, or if it was something that wasn't viewed, like the person didn't understand that was a conviction. We've seen this happen sometimes when people have an expungement and say, no, I don't have a conviction, because they've been told that their criminal conviction has been done away with. And so they no longer have a criminal conviction. And so they honestly, truly believe that. You end up having to explain that. But yeah, it will lead to you being found, one, being denied the relief, and two, potentially being charged with fraud or being determined to have committed fraud in your application. So be very careful with disclosing that information if it's there. Again, another reason for why to do an FBI check if you can, and if you have the time, just to see what the government has on your client. It's always better to be safe on that end.
And then one last question that kind of goes right into our next slide is, are there any current resources that you recommend, since this is such a complicated topic?
Go ahead, Wendy.
Yeah, I mean, there are lots of resources, not enough resources. I shouldn't say lots. It depends. It depends. I think if you're representing somebody who's got criminal convictions from like routinely from a specific state, trying to find Crim-Imm experts that are experts in that state. Like, I'm an expert in Massachusetts criminal law and the consequences of those offenses. I know how to do the research to figure out if a criminal offense from another state is a deportable or inadmissible offense, but I'm not an expert on that. And so trying to find a local Crim-Imm expert, there are also, national organizations that have lots of sort of definitions, discussions, practice advisories about this area of law. One thing I would advise people strongly about is that some of the national organization list charts that have been done by individual states, and those charts are more or less reliable. Like Massachusetts, we used to put out a chart like this criminal offense has the following consequences. We stopped doing that for a whole variety of reasons, and because we found it was more harmful than helpful. And so I still keep finding old charts of ours that are no longer good law on national websites. So be really careful about those charts and always use them. If you're going to use them only as a starting point for research.
Yeah, completely agree. And then, yeah, it's going to depend on what you're dealing with. But there's, ILSAA has a bunch of books that are great on immigration criminal consequences or immigration consequences of criminal procedure or criminal convictions. So there's a lot of resources, again, not enough, but there are individualized, and there's especially a lot for like the Ninth Circuit. Ninth Circuit has tons. So
Ninth Circuit has it all online too. I would say Immigration Law and Crimes, it was originally written by Dan Castlebrenner. That's a really good resource. And Kurzban is an excellent resource that goes into less detail, but is easier to find what you're looking for. So.
And our last slide. This is just some information on ILSAA resources as related to our peer networking hub. And you're going to get a copy of all these slides. And if you're interested in joining the peer networking hub or want more information, please email Amber Black at icf.com, and her contact information is on there. And last slide, please. Thank you so much to our wonderful presenters, Wendy Wayne and Homero Lopez Jr. It was a fantastic discussion today, and I know I learned a lot. Thank you so much for today. It was a joy having you.
Thanks for having us.
Yeah, thank you.